Could you imagine a murderer, rapist, or child predator getting off scot-free just because their case couldn't go to trial quickly enough? Well, it's happening right here in Canada, and the Alberta court system is already a total mess. Reports of judge and prosecutor shortages, which are causing delays in getting cases to trial, have been ongoing for years. Key positions aren't being opened and filled fast enough, and that's the job of both the provincial and federal governments. And the Jordan decision that was passed down by the Supreme Court last year is just aggravating the situation. This is the ruling that sets limits on court hearings under the premise that those accused of crimes have a right to be tried in a reasonable amount of time. So what's being done about all of this? Well, don't be fooled by this CBC headline. The feds aren't doing their job in filling new positions at all. In fact, Alberta Justice tells me that 15 of the 16 appointments made over the last 2 years to the Court of Queen's Bench were to fill vacancies due to retirements or because judges were simply elevated to different positions. There are still 14 vacancies on the Court of Queen's Bench and 2 on the Court of Appeal. The NDP also promised $14.5 million to the justice system and hired 50 Crown prosecutors along with 30 new court staff. But due to the backlog in the justice system resulting from shortages in resources and the Jordan ruling, serious cases can be dropped. Provincial cases now have a deadline of 18 months, while federal cases have a deadline of 30. And this article in the Star highlights the severity of the problem. Over 200 criminal cases across the country have now been scrapped under the Jordan ruling. According to Alberta Justice, as of November 13th, 145 Jordan applications have been filed since October 25th, 2016. Out of those, 9 are pending, 11 have been granted, and 13 have been proactively stayed by the Crown. That may not seem like a lot, but it means the Jordan decision is being used as a legal defense. Consider the case of 7-year-old Ryan Lovett, who died of a strep infection after his mother Tamara failed to bring him to a doctor and instead used herbal remedies in hopes of treating the infection. She was found guilty of criminal negligence causing death, but her lawyer now argues that proceedings should be stayed due to unreasonable delay. It's up in the air as to whether that delay is at 32 or 38 months in her case. But David and Colette Stefan were punished with jail time and house arrest after being charged with failing to provide the necessities of life for their 19-month-old son, Ezekiel. He died of bacterial meningitis after the parents opted to use natural remedies instead of bringing their child to a doctor. The major difference between these cases is that the Stefans were sentenced and Lovett has the potential to walk free due to the Jordan ruling. How is that a square deal for a helpless child? Yes, the NDP created these new positions in October of 2016 and also approved funding for more resources, but it was too little too late. The Jordan decision was made in July of 2016, and now we're seeing criminals being let off the hook. This has been an ongoing problem since the Progressive Conservatives were in charge. But you know what? Credit where due. The NDP are attempting to do something about the problem right now. And the feds? Well, they're doing almost nothing to alleviate the situation. They're delaying justice for victims of crime by ignoring their duties in filling important roles. So, while they preach about social justice issues like gender parity and wage gaps, they fail real victims, and that's a real mess that the Liberals need to clean up. Delivering justice isn't a partisan issue, and victims of crime simply deserve better from the government. For the Rebel.media, I'm Holly Nicholas. Thanks so much for watching. Make sure to visit our website and check out our all-new lineup of full shows if you haven't already. Best of all, you get it all for just $8 a month.